Has the Sheriff's Department or other government organization published false information about you, such as an arrest, and you want to know if you have a cause of legal action? By the end of this video, you will learn if you can sue a Sheriff's Department for reporting false information about you. Hi, I'm Nate Woodward, an attorney here at Minc Law, the nation's leading law firm when it comes to internet defamation and online harassment. Finding an inaccurate police report or falsified document about you online can cause serious harm to your reputation and future professional prospects. In this video, I'm going to walk you through if and when you can sue a Sheriff's Department for reporting false statements or information about you, why suing a Sheriff's Department or government agency may not always be the appropriate course of action, and your legal remedies if they do publish or report false information about you. If you find yourself at the center of false accusations by a Sheriff's Department, it's important to understand that police and other government agencies are typically protected by a legal doctrine referred to as privilege. In this context, privilege is a defense to a legal claim that protects many government actors from being held liable for inaccurate statements made in the course of their government work, so long as they are also made in the public interest. Depending on the nature and context in which the statement is published and the law of the state that you live in, it may be classified as either absolute or qualified privilege. Absolute privilege is effectively a complete bar to bringing a lawsuit, while qualified privilege means that you must show that the statement was made with knowledge that it was false or with reckless disregard for the truth. These defenses make most lawsuits against law enforcement a long shot, and in many states you could end up paying their attorney's fees in addition to your own. This is why suing a sheriff's office or police department for reporting false information about you is almost never a good idea, except in the limited circumstances we will discuss next. Although these types of officials are not typically able to be held liable for publishing false information about you, if you can prove that they acted outside the scope of their duties or engaged in misconduct, you may be able to sue them for damages. There are several situations where legal liability may extend to a sheriff's department. For example, if you are falsely arrested without probable cause that you committed a crime, the false police reports generated by that arrest could give rise to a claim against the department or the individual officers involved in the false arrest. A press release alerting the media to your false arrest may also be considered defamatory, but note that news articles accurately relaying statements by police generally are not. Courts have also held that law enforcement may be held liable for publishing false allegations and mugshots on department-run Facebook pages or on Crime Stoppers websites. Likewise, if an officer or deputy knowingly falsifies an affidavit in support of a request for a search or arrest warrant, the officer or government subdivision may be liable for damages resulting from those known falsehoods. Remember, each of these cases will require you to prove that the police acted knowingly or recklessly, not just negligently. Depending on the particular facts of your case and the harm you have suffered, you may have claims for defamation, false arrest or malicious prosecution, and violations of civil rights under state or federal law. Let's take a further look. To succeed in a defamation claim, you generally must prove that the false information was communicated to a third party, that it was harmful to your reputation, and that it was made with actual malice or, in some cases, negligence. Actual malice and negligence simply mean that the person who communicated the statement about you did so with knowledge of its falsity or reckless disregard for the truth, or did not take reasonable care to ensure that the information was accurate. This can include fabricating allegations based on false evidence or claims of officers, as well as knowingly making false statements to the media or public about you. In claims against law enforcement, if the statements in question fall under qualified privilege, you will likely need to show that the speaker acted with actual malice. If the false information reported by the Sheriff's Department or government agency resulted in a violation of your due process rights or other civil rights guaranteed by statute, such as the Civil Rights Act, Americans with Disabilities Act, or the Constitution itself, you may be able to sue for a violation of your civil rights. For example, if the false information is used as the basis to justify a wrongful deprivation of your right to life, liberty, or property, or to discriminate against you based on your race, sex, age, ability, or other protected status, you may be able to recover on those grounds as well. Finally, it's important to note that the specific circumstances of each case will determine whether or not you have a viable legal claim, and we generally recommend that you consult with a qualified attorney who can advise you on your available legal options. If you are arrested or prosecuted for a crime that law enforcement has no probable cause to believe you committed, you may also have a cause of action for false arrest or malicious prosecution. A false arrest may become a malicious prosecution if charges are filed against you based on fabricated claims. If a sheriff's office knowingly makes false statements about you and you suffer harm to your career, health, finances, or reputation, you may be able to file a lawsuit to recover damages to remedy the harm you've suffered as a result of the false publication. You may also be entitled to injunctive relief, ordering that the sheriff's office cease its unlawful behavior. Even in cases where absolute or qualified privilege prevents you from suing, you may have other remedies available to you. For instance, you can contact the Sheriff's Department or media outlet requesting that they correct or retract the false information about you. Many law enforcement agencies have also established procedures through which members of the public can bring formal complaints and request changes. If you or someone you know has been the subject of false reports or information reported by a Sheriff's Department, don't hesitate to seek professional legal advice to determine if you have a valid claim. You can contact us at Minc Law by filling out our contact form at minclaw.com, speaking with a chat representative, or calling 216-373-7706. This is Nate Woodward. Thank you for watching, and don't forget to subscribe for more legal insights.